Good afternoon, class. Today we begin one of the most practical and most litigated parts of commercial law, transportation law, with focus on negligence and liability of common carriers. This is not just theory. This subject is built from bus crashes, ship sinkings, lost cargo, airline delays, overbooking, and baggage problems. So when we talk about transportation law, we are really talking about how the law protects the public when they entrust their lives and property to carriers. Let me give you the guiding principle right away. Because the public entrusts lives and property to common carriers, the law demands extraordinary diligence from them. By the end of these sessions, you should be able to explain when and why a carrier is presumed negligent, identify the limited defenses available to carriers, apply doctrines to passengers, baggage, cargo, and airlines, and understand how courts compute and justify damages. Part 1. The foundational rule, extraordinary diligence. Let's start with the core rule. Under the Civil Code, common carriers are bound to observe extraordinary diligence over the safety of passengers and over the preservation of goods. Now, pause here. This is not ordinary care. This is not reasonable care. This is the highest degree of care that human prudence can provide. So, if you're asked in recitation what standard of care applies to common carriers, your answer should be extraordinary diligence. The presumption of negligence. Here is where transportation law becomes very powerful for plaintiffs. Once a passenger is injured or dies, or goods are lost, destroyed, or deteriorated, the law automatically presumes that the carrier was negligent. So, what does the passenger or shipper need to prove? Only two things: that there was a contract of carriage and that there was non performance, injury, death, loss, or damage. They do not need to prove negligence. At that point, the burden of proof shifts to the carrier to prove extraordinary diligence or to prove that the loss was due to a legally recognized defense. Part 2. How courts analyze accidents. Let's see how courts apply this in real life. 1. For improperly parked vehicle. In Batangas Transportation versus Kagimbal, a bus stopped improperly on the highway. Another bus crashed into it and a passenger died. Now, the first bus argued, Your Honor, the other bus was reckless. That's a fortuitous event. The court said no. Why? Because the first bus was also negligent in stopping improperly. The rule to remember is if negligence of the carrier concurs with a fortuitous event, the carrier is still liable. Vehicles or a vehicle bumped from behind. In Rainera versus Hiseta, the court said the rear driver is presumed negligent. Why? Because in ordinary experience, the rear driver usually has the last clear chance to avoid the accident. 3. Violation of traffic rules. Under 2185 of the Civil Code, if a driver violates traffic rules, negligence is presumed. That's what happened in Malyari versus Say. So remember, traffic violation equals presumption of negligence. Part 3. Injuries caused by employees and other passengers. A. Acts of employees, even beyond authority. Let's go to Maranan versus Paris. A taxi driver tried to rob a passenger and killed him. Taxi company said, Your Honor, that was a crime. That was beyond his authority. The court said, that doesn't matter. Under Article 1759, the carrier is still liable, even if the employee acted beyond authority or even criminally. Why? Because passenger safety is the carrier's responsibility. B. Acts of other passengers or strangers. In Manila Railroad versus Ballesteros, a passenger drove the bus because the driver left the key in the ignition. The carrier was still held liable. The test is simple. Could the carrier's employees have prevented the injury by exercising due diligence? If yes, and they failed, the carrier is liable. Now, what are the defenses of the carrier? Take note that this is a closed list. Now, this is very important. Once negligence is presumed, the carrier can escape liability only by proving one of these. One, fortuitous event or act of God, act of public enemy, act or omission of the shipper, defect in the goods or packaging, act of competent public authority. This list is exclusive. If the cause of the loss is not in this list, the carrier is liable. In fortuitous events, like Ubido, in the case of Ubido versus CA, to be a true fortuitous event, it must be independent of human will, unforeseeable, impossible to avoid, and without any contribution from the carrier. So, is a tire blowout a fortuitous event? Usually no, because maintenance is within the carrier's control. Is bad weather automatically a defense? Also no. The carrier must still show extraordinary diligence. Now let's go to contributory negligence and last clear chance. Contributory negligence under Article 1762. If the passenger is partly at fault, it does not bar recovery. It only reduces damages. Exception: if the passenger's act is the proximate cause of the injury, the carrier may be absolved. Classic example is when a passenger is taking arm outside the window. Doctrine of last clear chance. This doctrine mainly applies in quasi-delict cases between drivers. It does not apply when a passenger sues the carrier based on contract. In Chu versus Arriesgado, the court said it would be unjust to excuse a negligent carrier just because someone else was also negligent. For special systems, kabit and boundary. For kabit system equals franchise holder allows another person to operate under his franchise. The law says this is void for being against public policy. Lin versus CA. But to protect the public, the registered owner remains liable and the actual operator may be solidarily liable. For boundary system, even if the driver pays boundary and keeps the excess, the relationship is still usually employer-employee and the owner remains liable, as held in Magbuo versus Bernardo, Hernandez versus Dolor. You cannot escape liability by clever arrangements. Now let's go to airport transportation law. Nature of airline contracts. In PAL versus CA, even when a flight was diverted due to force majeure, the airline was still required to exercise extraordinary diligence toward passengers. The important rule here is when the contract of carriage continues until the passenger, the contract of carriage continues until the passenger has safely left the carrier's premises. Airlines are engaged in business affected with public interest, so courts hold them to strict standards. How about abuse of claims? In U Eng Cho versus Pan Am, the court warned that airlines should not be treated as, in quotation marks, trophies in a safari. Not every inconvenience equals damages. There must be real bad faith or legal basis. Now let's go to common airline issues. Let's run through the usual problem areas: bad faith and moral damages. Recoverable only if death occurs or there is fraud slash bad faith, as held in Morris versus CA and Air France versus Gallego. Travel documents. Airline checks documents but does not guarantee admission, as held in JAG versus Asuncion. Overbooking. Overbooking is allowed but failure to inform passengers would be equal to bad faith. Salamia versus CA. Baggage handling. Safety-based rerouting is not willful misconduct, as held in Tan versus Northwest. Let's go to damages in transportation cases. A, for actual damages, hospital bills, medicine, proven expenses. B, loss of earning capacity. Here's the formula: life expectancy times open parenthesis gross annual income minus living expenses close parenthesis, where life expectancy equals 2/3 times open parenthesis 80 minus age close parenthesis. Living expenses equals 50% of gross income. This is applied in Davila versus Pal, Irina versus Sarati, and many others. For moral damages, in culpa contractual, the general rule is not recoverable unless there is bad faith. Exception is if the breach results in death. Moral damages are awarded even without bad faith. Philippine Rabbit versus Esguera, Sulpicio Lines versus Corso. But only for the spouse, ascendants, and descendants to recover, not siblings. For Part 10, the Warsaw Convention, International Air Carriage. The Warsaw Convention has force of law in the Philippines, applies to international transportation, imposes liability limits but allows exceptions. Carriage is international if departure and destination are in two contracting states, or they are in one state but with an agreed stop in another. Key rules: $500 per package limit unless higher value is declared. 2-year period to sue, and willful misconduct removes liability limits. PAL versus CA, United Airlines versus UI. Also remember, Warsaw does not bar civil code claims for humiliation or rude treatment. Let's now go to cargo bills, bills of lading, and COGSA. When carrier liability begins and ends, begins upon unconditional receipt of goods and ends only upon actual or constructive delivery to the consignee. For bill of lading, there are three functions: evidence of the contract, document of title, and receipt for the goods. A clean bill of lading is prima facie proof that goods were in good order. Now let's go to COGSA, or the Carriage of Goods by Sea Act. Key points: $500 per package limit. Notice of loss immediately or within 3 days. Suit must be filed within 1 year, not told by demand. For arrestry operations, arrestry operators handle unloading and custody of goods are bound to extraordinary diligence, may be solidarily liable with the carrier. Management contracts usually impose 30-day claim period, 1-year period to sue, and limited liability unless higher value is declared. Now here are some commercial terms: if OB, if AS, CIF. If OB, Ownership passes at loading, buyer bears risk. If AS, delivery alongside ship, similar to FOB. CIF, seller pays cost, insurance, freight. Ownership passes at destination, seller bears risk in transit. This affect risk of loss, insurable interest, and commercial and tax consequences. In closing, let me leave you with these anchors. Common carriers are presumed negligent once loss or injury is shown. Defenses are limited and exclusive. Extraordinary diligence is the standard. Airline, cargo, and arrestee cases follow the same public protection philosophy. Damages are structured, not discretionary. Warsaw Convention applies to international air carriage, but civil code remedies still exist in proper cases. If you master the sequence, status, standard, presumption, defenses, damages, you will be able to solve almost any transportation law problem in exams and in practice. Thank you.